Today we're going to be looking at chapter 11 in the text concerning sentencing. There are several functions and goals of punishment and reasons why we sentence people in the criminal justice system. The first, probably oldest kind, the kind that we try to move away from, is retribution, sort of getting even with an individual. That's one of the reasons why we don't have the person who's the victim of a crime represented in the criminal case. It's the people versus the individual, or the state of Georgia versus the individual, as opposed to being the victim versus the individual in the criminal case. We're trying to move away from retribution. The next is incapacitation. This is basically preventing someone from committing a new crime while they're incarcerated, or through various correctional supervision elements. The next is deterrence, both specific deterrence, preventing the individual from committing crimes, but also general deterrence, in that if people see others punished for crimes, the thought is that they will not commit those same crimes themselves. It will sort of go into their calculation of whether or not they're going to commit a crime or not. And again, that relies on the criminals themselves being logical to some degree. The next, probably the most important, but one of the least focused on, is rehabilitation, making the person better so they don't commit crimes in the future, so they can become a productive member of society. Lastly is restoration, where we try to give the victim some normalcy, basically restoring their life to the way it was before they were the victim of a crime. The two major sentencing models that we have are either a indeterminate sentence or a very structured determinate sentence. Indeterminate sentence is basically just a range. If someone gets 5 to 10 years, 10 to 20 years, something like that, where there's leeway on the top end and the bottom end for how long the person's going to be in prison. Most sentences that we have today are handed down are determinate sentences, structured sentences. And basically that means that the defendant is sentenced to a very specific number of years or months. Very frequently they do it in months now. So instead of receiving a 5-year sentence, the person will receive a 60-month sentence. It just lets the court system and the Department of Corrections work on the same measuring tool of when the person is going to be eligible for early release. There are some differences in the in federal sentencing models. Some states have those truth in sentencing laws that we've talked about in the past, but for the federal system, that's pretty much for everything. There is no federal parole anymore, so most people that are sentenced for federal crimes are going to have to do the vast majority of the sentence that is handed down. One of the major issues constitutionally that's come up in related to sentencing is has to do with what factors of the case can be considered during the sentencing process. And a couple Supreme Court cases listed here basically say that anything that might increase the sentence, the punishment that the person is going to be facing, has to be considered by the jury. You can't, for instance, add a hate crime addition to a conviction after the jury has already made their verdict, and then sentence based on that. All the conditions that are represented in the sentencing phase that might have increased punishment for the crime have to be considered by the jury, or in the case of a bench trial, by the judge during the trial process, as opposed to during the sentencing phase. As we've said before, there's been a lot of increase in the correctional population. We talked about that over the course of the semester. Two of the main culprits behind that are 3 strikes laws, which basically say that no matter what the third felony is, the person's going to receive a life sentence. It could be 15 years to life, it could be 20 years to life, it could just be a straight life sentence with the possibility of parole, or life without the possibility of parole, depending on where the crime has taken place. Additionally, mandatory minimums have reduced the discretion on behalf of judges. And we talked about before, judges have a pretty wide discretion in the court process. Mandatory minimums remove a lot of that and say if the person is convicted of a particular crime, then they have to be sentenced to this amount of time, which further empowers the prosecutor's office actually in the court process. Some innovations in sentencing that have come up recently. It's only been about the last 200 to 300 years as a society, global society, that we've put people in prison at the rate that we have. Before that, there's more reliance on immediate punishments, typically physical punishments or fines. So there's been a push recently to try to reincorporate some of those immediate punishment, not necessarily physical punishment, but some of the more immediate things to resolve the situation without having to go through a court process. Some of those things could be sentencing an individual to stand on the side of the road with a sign detailing the crimes that they committed, sort of reintegrated shaming process. So there has been an increased frequency of these non-traditional sentences, alternative sanctions, in the last maybe 20 to 30 years. They receive more attention now if they get picked up on a news cycle. We've also seen a push, some pro-victim, some pro-defendant movements over the last 20 to 30 years. A big addition to the pro-offender movement. Pro-offender is a rough phrase, but for benefiting the defense during the sentencing phase is a pre-sentence investigation, which is typically conducted by a probation officer, and the goal is to give the court the most complete picture of who the offender is and what potential sanctions would be most beneficial towards rehabilitation of the offender. We've also seen some movement the other way in terms of victims' rights. There's been a lot of pushes towards increased focus on victims' rights in criminal cases, letting them know when proceedings are going to take place, letting them be an active participant in the proceedings. If their testimony is not relevant at trial, allowing them to testify during the sentencing phase through victim impact statements. So there's been a fair amount of push, really starting in the late 1970s, to increase the role of the victim in the criminal process. The sort of rate that we see in terms of people being sentenced every year, we have about 1.1 million convictions every year as far as felonies go. Quite a bit more than that of misdemeanors and ordinance violations. About 41% of them go to prison, 28% go to jail. The average time for incarceration for a felony conviction is about 5 years. About half of that time is spent inside. The other time is reduced through good time, through early release from parole, things like that. Following release, 27% of them also have to serve in addition to those released that have to do probation post-release, there's also a fair percentage that are just released onto probation following the trial process. So about a little less than 30%, 27%, actually do not receive any incarceration. The average time on probation is a little over 3 years. The number one driver for putting people on through this process for felony convictions is drug crimes. So now we're going to talk about the most serious form of sentencing punishment that we have in the United States is the death penalty, which is still an option for sentencing in 30 states, as well as the federal government and the military. This first slide is a map of countries around the world that have the death penalty and those that do not. This is a legal history of cases related to the death penalty. I would like you to look up each of these cases, read some facts about it. I would recommend OEA.org. You can look at the Wikipedia sites for these. They're pretty informed. But just follow these cases, look them up, and sort of see how the law has progressed in relation to these death penalty Supreme Court cases. But it is important to note one thing that might not be readily available. When a moratorium was placed on the death penalty following the Furman versus Georgia decision, there were still some individuals left on death row in the United States. Those that were sentenced by the federal system and those that were sentenced by the military system. So it didn't remove everyone from death row in 1972, but it did remove the vast majority. And we'll see that in some slides going forward. As I said, capital punishment is a sentencing option in 30 states and with the federal government and the military. There are differential levels with which states actually execute individuals. So though a majority of states have the death penalty as an option, there aren't that many executions in a lot of those states. They're fairly heavily clustered within a few states that execute a lot of individuals, and a lot of states that execute very few. Some, like California, still have the death penalty on the books, but they haven't executed anyone in almost 20 years. This is a look at the population of individuals on death row. As I said, there are a few at the top: Florida, Texas, Alabama. Here in Georgia, we execute a fair number of individuals that execute fairly frequently. The state with the highest population is California because they don't execute individuals. They will sentence individuals to die, but they will not actually carry out the sentence, or they haven't in a number of years. This next slide is looking at a graph of the death row population by year. As you see, it dropped sharply in 1972, almost bottoming out, except for the federal and military individuals, and then ticks back up throughout the 80s and the 90s, and then levels off after a brief decline in the early 2000s. We see on the next slide similar representation in terms of the number of executions carried out each year. It rises with the population, sort of peaks in the late 90s, and then goes down and sort of levels back out again. So there's sort of again, equilibrium that's been reached in terms of the people that are coming on death row and coming off of death row. The population size has stayed relatively stable over the last 20, really 15 years. As we see more, about the same number of people coming on death row as coming off. The other way that people leave death row is through exonerations or commutations. There have been, as you see, over 100 exonerations since 1973. That number has been going down recently. Part of the reason there was such a high number of exonerations in the 1990s, 2000s, is because of the substandard levels with which trials were conducted in the time before that. Evidence that shouldn't have been allowed, evidence that was excluded, evidence that wasn't able to be tested. So the number of exonerations per year has been going down as we have seen an increase in the standards of that trials are held to. So as that increased through the 90s, through the 2000s, through the last decade, there have been less instances where trials have been found to have reversible problems. The next slide shows again that sort of cluster of executions where the crimes have taken place. As you see, there's a lot that have taken place in Texas, around major cities. Usually, people are more likely to face the death penalty in rural areas, but there are some exceptions in places where they're more frequently using the the death penalty, and you see that around Houston, Dallas, popular areas in Texas, also in Oklahoma, Missouri, and then Arizona around major cities there. So there are some things that go against the pattern when we look at where executions take place in terms of in rural areas versus in more urban areas. Okay, the last slide we're going to look at is basically the crux of why executions were halted in 1972, and hopefully you took some time to review the Furman cases and the Gregg cases as listed earlier in the slide. First, the Furman case said that the death penalty was handed down with a racial bias, in that black defendants, especially those who killed white victims, were much more likely to receive the death penalty than white defendants that killed black victims or white victims, either way. By introducing the sentencing phase in the Gregg case, the Supreme Court said that the state of Georgia had done enough to reduce this bias, but these numbers clearly show that has not happened. As far as race of the defendant, black Americans are much more highly represented in the defendants in terms of the race of the defendants in these cases. Seen almost a third of defendants in these death penalty cases being black, versus making up about 12% of the overall population. So it's almost a 3 times representation there. Additionally, when you look at the race specifically of the offender and the victim, it's very apparent that black defendants that kill a white victim are much more likely to face the death penalty than any other combination of racial group, especially when you look at the opposite, a white defendant with a black victim, there's very little likelihood of facing the death penalty. Further, when we look at the way that this system plays out, the sort of courtroom work group effect, 98% of the prosecutors that handle death penalty cases are white. It's not necessarily saying that they are biased, but they are excluding some of the cultural, social backgrounds that might be relevant towards deciding whether or not to bring the death penalty in a particular case or not. So we're losing some of that review of these cases from alternate perspectives that we might see if there was more minority or at least non-white representation in prosecutors' offices related to death penalty cases. Okay, so make sure to look up those Supreme Court cases that were listed earlier in the PowerPoints. Read the chapter in the text and watch the video that is linked about the death penalty in the to-do list.